This is the B.ED matter from Chhattisgarh, your lordships were considering, Manoj, prior to the vacation.
This is that Devesh Sharma, Manoj, and
Devesh Sharma on the B.ED one, Manoj, that the process of recruitment had already started. There are similar matters, Manoj, which were filed just before the vacations, your lordship were considering. Your lordship may, because the subject matter requires some consideration, Devesh Sharma's clarification order, which was passed in Madhya Pradesh's case, Chhattisgarh and other states were not noticed in that. What happens, Manoj, as a result is those who were in the process of appointment prior to Devesh Sharma's judgment are now out, Manoj, because that NCT amendment was struck down. However, Ram Sharan Mauryan's case, Manoj, which is exactly the opposite, upholding the NCT amendment, allowing for B.ED degrees, Manoj, to be a qualification for assistant teachers, Manoj, that was not noticed, Manoj, in Devesh Sharma's case. So as a result, Manoj, there are two contradictory orders which would be there. Required some lordship's consideration was there prior to that.
That may not be the correct stand for one reason, Manoj. In the present state, all appointments are pursuant to Devesh Sharma, Manoj. 11.8 is the Devesh Sharma judgment. The first appointment letter, Manoj, was issued on 22nd September 23. There have been at least 10 applications by different states in the form of review or SLP where this honorable court's judgment has been followed. All of them have been dismissed. Some have been dismissed with cost. I have a chart for that. So, Manoj, the ground that they are taking that there was some notice or some judgment that was not brought to the knowledge of the honorable bench when 11.8 was passed has been argued at least 10 times till today, Manoj. And they're not disclosing that. That's number one. Number two, Manoj, what was there in that MA was the period that prior to Devesh Sharma, if there was any appointment, that is when the matter came to Supreme Court against the Rajasthan High Court judgment, were there any appointments? What would be the course of those appointments? That was the only clarification that MA, the scope was limited. The present case, Manoj, in Chhattisgarh, where the impugned order has been passed, all appointments, admittedly, are only on 22nd September, which is almost 1 month after Devesh Sharma. So when there is a clear-cut judgment where the review again by this court has been dismissed, the MA has been dismissed by multiple states, there have been costs that have been imposed on these B.ED students. And what they are doing is, Manoj, with due respect, Manoj, there is a direction in the impugned order. The impugned order has not been stayed by this honorable court. In fact, notice has also not been issued till today. In fact, there is a specific rejection of any interim stay on the last date when the matter came up before vacation. My lords were convinced to not even issue notice on that matter. The contempt came 3 days back before the High Court because till date, those B.ED candidates are continuing. Using the pendency of this matter, Manoj, the contempt is disposed of, saying that the SLP is pending, therefore the contempt will not be looked into, Manoj. So the fate of these D.ED students that I am representing, and I was the writ petitioner before the High Court, Manoj, a batch of them, is this: that we have succeeded in all forums throughout. Still we are out of job. Still, those students who were guaranteed
violation of Devesh Sharma.
Violation of Devesh Sharma, Manoj. And the fact that these at least 10 states, Manoj, have approached this honorable court pursuant to Devesh Sharma, and all of them have seen the same outcome, Manoj. All of them have been rejected. So therefore, Manoj, my humble submission is, number one, Manoj, if my lords would be kind enough to consider the matter specifically, because the state in the High Court has taken a different stand altogether. In fact, in their counter itself, they say whatever will be the outcome of the writ petition in the High Court, we will respect that. So that is my first argument on merit, that when they take a stand before the High Court, that whatever is the outcome of the writ petition, we will respect that. How today on merits can they file an SLP? That's number one, Manoj. Number two, Manoj, irrespective of whether there is no interim order granted by this honorable court, there is no notice issued by this honorable court, still since past 4 months, Manoj, the writ petitioners are jobless. And and candidates who have been declared incompetent by this honorable court are imparting education to children who are guaranteed, because in Devesh Sharma, one of the paragraphs was with reference to the education the children are getting, Manoj. So it is a violation of Article 21A for them. So those incompetent teachers, in my respectful submission, Manoj, for the past 4 months are being taught by these B.ED candidates. So in altogether, Manoj, the pendency of this matter is being misused. And I am carrying the latest rejection, Manoj, on the bench of Honorable Justice Gawai in a similar, identical matter from Uttarakhand, where I had appeared, Manoj, because, and as a caveator. The Uttarakhand High Court also followed the Devesh Sharma judgment. Exactly same grounds taken. The Honorable Court was pleased to dismiss.
All right. Yes.
I am.
You are appearing for?
There are 6 other SLPs which are pending, where your lordships have directed to be listed on 28th August for final hearing. But I appeared during the vacation court on the 3rd of July. And on the 3rd of July, after pointing out that in Devesh Sharma itself, what has been protected is if there is a state enactment made, then that state enactment will have to be seen. So that state enactment has been quashed today by this judgment. So those matters are coming up on 28th August. So that order, my lord, the office report shows the record of proceedings have been circulated to your lordships. I can hand over the copy of that order of the 3rd of July, where, my lord, the direction is.
I'm
So
sorry,
that
my lords,
point
that
of
may
time,
not be a
my
right
lords,
statement. That may not be a right
State's
statement, my
appeal,
lord.
my lords, had been,
Let it complete. Huh?
the state's appeal.
Anxious.
No, it's not a final hearing.
I'm only bringing to your lordship's notice what are the orders. Lord, first the matter came up before my lord, the Justice Vikram Nath, my lord, on the 13th of May. Since some matters were not listed on that day, the lordship directed the matter to be listed on 17th May. Unfortunately, on 17th May, the matters were not listed. Then my friends mentioned this matter, not when my lord was sitting as a vacation judge, but they mentioned the matter before Justice Dhulia when he was sitting as a vacation judge and got the matter listed on the ground that a contempt is pending. And on that basis, matter was listed. I have no quarrel on that. On 2nd July, the matter was, because nobody was present, the 3rd July matter was listed. On 3rd July, my lord, the order passed is, list the matters on 28A. We make it clear that we have not interfered in any manner whatsoever with the order which have been impugned before this court in all the above matters. So the matters are to be listed. I have pointed out that there is a conflict. That is the basis on which this order has been passed. And my lord, the matters are to be listed. Because the aggrieved teachers who have been appointed. And my friend to say that incompetent B.ED, B.ED is not incompetent, B.ED is a higher degree. Diploma in education is a lower degree. My friend's contention is that a higher degree.
Mr. Ranjit, what difficulty is
Yes.
for teaching the tiny tots who are in primary
Class 1
or
to 5.
So,
the special degree or the qualification which you acquire should be commensurate to that requirement of teaching,
here-
not for teaching the higher classes. You have a B.ED, you can be appointed as a teacher or a lecturer to teach up to class 12, correct?
so-
That is, so therefore, a teacher, how he deals with students of class 12 may not be so conversant with how to deal with students who are 5 years, 6 years, 7 years, 4 years, 3 years.
So therefore, my lord, that the lordship will examine because Justice Lalit, in his judgment in Ram Sharan Maurya, which is not even referred to in Devesh Sharma's case, my lord, has held that it is a valid notification and that notification should be one. So therefore, my lord, I am respectfully submitting that because of the conflict, their lordship, my lord, in the vacation court have said that they will hear these matters on 28th August.
Let these matters be heard, there is no problem. But let the High Court judgment be implemented.
Very well.
With respect, my lord, if it is
No.
with respect, kindly just see what would happen is
Let the High Court judgment be implemented. If you succeed, you will get back.
Very well, my lord.
sir,
Absolutely no problem.
My lord, therefore,
Yes,
you
yes.
have passed this order that we have not
Already clarified.
interfered and
Right,
clarified.
we'll make it clear.
That order will continue.
We will make it clear.
Yes, may I say that
It's already clarified, my lords.
Submitting that-
It's already clarified.
We will further clarify it so there is no further.
Once
In fact-
it's clarified, my lord, I am respectfully submitting that your lordship may not, with respect and humility, I say, lordship need not say anything, or lordship will only
It
direct.
requires to be said, otherwise what happens is there is a lot of misrepresentation and lot of communication. And the government gets a handle to play this way or that way. Why should we even allow that?
Because my
Let the
contempt has
judgment be
been
implemented.
disposed.
And the implementation of the judgment would remain subject to final outcome of the special peace.
My lord, there is no misrepresentation because I can show from Devesh Sharma's case judgment itself, where their lordship said, Justice Bose and Justice Dhulia, my lord, that when there is a, so here, my lord, what happened after the notification of the NTCE, the state made an enactment. Now that enactment, my lord, your lordships have in that judgment of Devesh Sharma saved. So therefore, my lord, that is why, my lord, it is important that the Devesh Sharma judgment, which my friends are relying on which the High Court has relied upon, for in this
You
case.
see, higher qualification or a higher degree is detrimental for actually discharging your duties
May-
where the requirement is lesser.
There is one.
In fact, my lords,
There is one more additional issue, my lord.
Yes.
The additional issue is that these persons who are appointed and who are working today for the last, my lord, for the last more than a year or almost a year, these persons had also applied for the higher categories. They were selected, but they did not take up the higher category because, my lord, what happens for the lower class, for primary class up to the 5th class, the teachers are required to be located in that area. So, my lord, nearby. So they took up these jobs and they gave up the other
That
jobs.
was your choice. You opted for this thing.
I am only saying,
Even you are leaving a higher pay scale and accepting a lower pay scale to become a primary teacher rather than a secondary teacher for some personal gains or for staying within your house or within your native village, wherever you want to. That's your this thing. That risk you are taking.
I'm only saying, Lordship may
No.
tag it in 1 month. Milord, why, Milord, I respectfully say, in 1 month, why, Milord, unsettle
We
the.
don't know whether it will take 1 month, 1 year, or 10 years, or whatever.
Listed on
I must clarify.
This is mere listing is not.
No, Manoj, my
Everyone
only
knows that what happens here.
Manoj, the state
In
subsidy
fact-
had been filed but was not listed.
No, no,
on
I'm
last-
sorry. That's not a right
That's coming
statement to
up
make.
later.
On the last date, state's appeal was not there.
We duly informed the court, Manoj, also.
Can I make one more submission? The other 5 matters are not listed today. I am saying they are against the same judge.
Whenever they come, they will tag it with them.
Yes, Manoj, what? In fact, that.
Clarification today, not any clarification today. Milord, if your lordship would list all those matters, have it tomorrow. No
We
problem.
are not actually clarifying anything. We are saying tag with these matters along with so and so and list on 28th August 2024. In the meantime, the implementation of the interim judgment shall remain subject to final outcome of this petition.
Very-
That's all.
Great.
Lordship,
Obliged.
lordship, please.
Can I just take 30 seconds, Manoj?
For what?
For only requesting this, Manoj. The contempt was filed in the High Court. The contempt has been disposed of, saying that the mere fact SLP is
We
pen.
challenge that order, we will see what is to be done.
Yeah.
Yes, next.
Great.
Lordship, please.
Lordship, please, and for the
Deeply
petitioner,
grateful, Manoj.
may Lordship